मेंशन करके अटेंडमेंट नहीं होता है.
From the daily cause list, under heading for orders with effect, item 1, DA 12030 of 2026, filing number.
File is proceeding at an advanced stage.
ये number serial number 1 है ना? The learning council for the 56 to withdraw this mail application.
Sign करा.
Mail application is dismissed as well.
Sign करा. Item 2, DA 1225 of 2026, filing number.
Effective है ये.
Yes.
Also same order.
Under heading for press filing, item 3, ABA 4339 of 2026.
कितना टाइम चाहिए? File counter affidavit based for that schools for the respondent state. Mr. Vineet Kumar Vashisht. Counsel for the petitioner seeks adjournment. However, thus opposite party is directed to file a counter affidavit in this case. Post this case on 27th, the counter affidavit will be filed by 20th of August.
Counter will be filed by 20th 20.
Appearance date.
Counter affidavit का date 20 August.
Item 4, ABA 4450 of 2026.
File was registered against a branch manager for misappropriation of funds from the SBI. The petitioner before your ladyship is a contractual worker who was engaged for cleaning of the branch. As per the charge sheet, the allegations against this petitioner is at page number 81.
Yes.
The allegations are Sunil Kumar Shah at room number 6 was engaged by the SBI Saibel branch through vendors for cleaning and maintenance work of the bank. However, he conspired with Manoj Kumar, within branch manager, and actively assisted him in the fraudulent activities. What activities have not been stated here? Munshi Soin, one of the witnesses, categorically stated that Sunil Kumar Shah collected his signed check for withdrawing the money transferred in his account.
The money was transferred in your account?
Yeah, it is nowhere in the records.
Yes, you see, also stated that Sunil Kumar Shah transferred rupees 1,49,000 in his account. Whose account?
That
Jagannath's.
is not clear, Your Ladyship.
And subsequently collected 2.5 lakhs in cash from him before his loan of 4 lakhs was sanctioned.
And this person, Jagannath, has not lodged any complaint against
Might
this
not
petition. Neither with the bank nor with any
See,
of
the person who is a beneficiary of the loan will not lodge a complaint. He will never. You file a complaint. Let's see whether there is any transaction in his account.
Lordship, what has happened in this case, Lordship, is that this branch manager, his anticipatory has been rejected, Lordship. He, along with all this petitioners, Lordship, they were withdrawing money from the pensioner's account, Lordship.
You file a complaint. The counsel for CBI
CBI.
is directed to file a counter affidavit in this case.
It's 4 weeks, Lordship.
You will also file the memo of evidence and also the memo of evidence collected against the petitioner in seal cover before this court. Post 127.
If I may read, Your Ladyship,
Counter affidavit be filed by 25th.
20.
till then no further steps will be
I can dismiss it. Right?
Relationship charging has already been submitted, comments has already been taken.
Appearance
Anticipated
is
bail is nothing.
item 5 DA 7070 of 2026.
Side. Diary.
Judgment has been submitted. We will not consider your bail application at the stage of investigation. Because lot of investigation is
About to submit.
about to, so we are not going to wait.
Not made.
No. No, not
It will be
today.
submitted, Lord.
No, no, no. You see, this,
Anticipated
no, no.
नहीं है, Lord.
But
घर से अरेस्ट किया है रात को 12 बजे।
कोई बात
सीडीआर रिपोर्ट भी मंगा लिया जाए तो घर से अरेस्ट
नहीं,
किया है।
नहीं, ऐसे नहीं होता है ना। ठीक है। There is an antecedent of similar thing.
हाँ, उसमें हम एक्विटेड हो गए। I have stated in para 18.
देखिए इन्वेस्टिगेशन स्टेज में it is very difficult. You should not
ढाई
file.
महीना हो गया कस्टडी में। And it is
अभी
about
तो
to
क्राइम
submit.
लिंक अभी तो क्राइम लिंक का पता नहीं है ना because investigation is going on. And I have rejected several cases which have been filed at the stage of investigation in cyber offense because victims are to be identified, the crime links is to be seen. There are so many work which is to be done by the prosecution. आपके पास तो सिर्फ मोबाइल सिम और वो सीज हो गया, उसके बाद इनका होमवर्क बहुत है. Not at the
घर
stage
से
of
अरेस्ट हुआ है लॉर्डशिप रात को 12 बजे सीडीआर रिपोर्ट मंगा लिया जाए।
आपके पास से कुछ रिकवरी है?
रिकवरी है जितना घर का सामान है जितना
कोई मोबाइल सिम रिकवरी है?
मोबाइल अपना खुद का मोबाइल है।
आपका खुद का मोबाइल
खुद
है?
का मोबाइल है। हम
कहाँ
ये
लिखे हैं?
स्टेट
कहाँ लिखे हैं कि the whatever has been seized is in your name?
para 10 में लॉर्डशिप। The police have not recovered any incriminating articles whatsoever from the process position of the petitioner. However, the recovery made from the petitioner belongs to the petitioner and his family and he was arrested from his house at midnight. Para 10.
These checkbooks and all these are in your name. Whatever has been
Family.
recovered, whatever has been recovered is in your name.
You see, that's why I have given the statement. It is belongs to the petitioner and his family.
But whose name? Family का detail बताइए भाई. Family क्या?
हम
Family तो
सब
पूरा
सारा
दुनिया
डिटेल्स हम
family.
बता देते हैं
A
लॉर्डशिप।
supplementary file. And you see, this is not the way. I'm just telling you, I will not entertain cybercrime matters at the stage of investigation.
I will keep it.
पेज नंबर 18 एक बार देख लीजिए।
18.
हाँ, पेज नंबर 18
हम्म।
नीचे से 7 बरामद मोबाइल फोन से मिले साक्ष्यों का स्क्रीनशॉट लिया गया। नीचे से 7 स्क्रीनशॉट लिया गया। एक काला रंग का एप्पल कंपनी का आईफोन का जांच पड़ताल करने पर पाया कि टेलीग्राम का डीके बॉस के नाम से मोबाइल नंबर इतना से लॉगिन है। टेलीग्राम पर कई ग्रुप बने हुए हैं जिसमें साइबर ठगी से संबंधित फर्जी लिंक एवं अन्य लेन देन किया गया। बरामद मोबाइल फोन से मिले साक्ष्यों का स्क्रीनशॉट लिया गया।
All the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, and so far as the antecedent is concerned, the petitioner has already been acquitted in the same case. You have annexed a copy of order of acquittal.
Supplementary था।
The order of acquittal. However, the order of acquittal has
Para
not
18
been
में
rejected, has not been annexed along with the bail application. He has stated so in paragraph 18 of the bail application. The petitioner is in custody since 23/5/2026. He submits that all the incriminating articles which were recovered from the possession of the petitioner belongs to the petitioner and his family members. Counsel for the state has opposed the prayer for bail and has submitted that investigation is still going on. And as per the FIR itself, it has been found that apart from the other recoveries from the petitioner, one mobile has been recovered which is logged in the name of DK Boss inverted comma value. And a number of groups have been found and lot of links have been found in connection with cyber offense. And number of screenshots have also been found in the
APK file
mobile.
is also there.
This
Next
one-
page.
Sorry,
नेक्स्ट पेज 19 में फर्स्ट लाइन पेज नंबर 19 इनके मोबाइल फोन में कई फर्जी एपीके फाइल कई
and in his mobile, numerous forged APK files have been found. After hearing the learned counsel for the parties and considering the incriminating articles as mentioned in the FIR itself, and the investigation is still going on, this court is not inclined to enlarge the petitioner on bail.
At this stage.
It's always at this stage.
Item 6, DA 7072 of 2026.
Fair issue 376, 323, 506, 313.
The state is directed to serve notice upon the informant of the case. Charge sheet हो गया? Charge sheet.
Okay.
Let the statement of the victim recorded under section 183 BLS is called for from the concerned court, along with the CD, along with the case diary and its enclosures. The state to file counter affidavit also on the minutes. The counter affidavit will be filed by 21st August, post on 25th.
Item 7, DA 7077 of 2026.
Counsel for the petitioner seeks permission to withdraw this bail application. Permission is accorded. This bail application is accepted.
Sign the bill. Sign the bill. Item 8, DA 7088 of 2026.
Speaking about day before yesterday, I had withdrawn. My bail application was another similarly situated to a person because charge sheet was not submitted. Therefore, I
Still, the
had
charge sheet has not been submitted.
in this case also.
Counsel for the petitioner seeks permission to withdraw this bail application. This bail application is dismissed.
And this is still in the order.
It is always at this stage.
Sign the bill. Item 9, DA 7093 of 2026.
But withdrawn the case earlier. Oh, you were pressurizing the victim to withdraw her earlier case. Anyways, when do you want? You don't know. कौन है सीनियर? पूछना चाहिए ना कब करना है? Counsel for the petition seeks adjournment. तो नहीं है क्या कोर्ट में? On account of non-availability of our main counsel, Mr. Gautam Kumar. At his request, post on Monday.
Appearance दीजिए. Item 10, DA 7095 of 2026.
इसमें दो कोई भी उसका बेल रिजेक्ट नहीं नहीं
से स्पेसिफिक लिमिटेशन में जारी कर दिया जाता है। इस पर आया है हमारा संपर्क क्रिएट कर दूं। ये जो है बचाने वाला था, ये जो मार्कफिट नहीं कर रहा डायरी और री स्टेटमेंट में इसका नाम नहीं है मेरे पास डायरी है
ये वाला जो है ना
जी
ये जस्ट अ मोमेंट किसको भेज दिए हैं नाम बताइए संतोष साव केस नंबर बताइए केस नंबर
ये है 6407/2024
ऑर्डर का कॉपी है
हाँ मेन इरिगेशन इसी पे
इसमें केस डायरी हुआ था ये जरा देखिए
नहीं हुआ। नहीं।
6407/26 केस डायरी हुआ होगा
मेन इरिगेशन इसी पे
6 मेन एलिगेशन इसमें नहीं है 6407/26 में देखिए तो केस डायरी हुआ था
देखो
इंडिपेंडेंट विटनेस बोल रहा है कि बचाने वाला डायरी हुआ है
हुआ था ना इसका केस डायरी लेकर कल लगा दीजिए BA number 7095 of 2026 office is directed to place the case diary which was called for in BA number 6407 of 2026 and the same case has been disposed of on 3/8/2026 केस डायरी लगाइए और कल चलिए कल सुनते हैं बाकी दो का दो बेल रिजेक्ट हुआ वो भी लगा केस डायरी आपकी जरूरत नहीं है केस डायरी केस डायरी कोर्ट में आया हुआ है ना मल्टीपल केस डायरी का कोई काम नहीं
वापस ले लिए थे
स्टेट को डायरेक्शन था कि ये सबमिट अप टू डेट केस डायरी तो स्टेट को ले लिया हूँ कॉल फॉर नहीं हुआ था फॉर द केस 13 जुलाई को हुआ
इसमें स्टेट के काउंसिल कौन है
चिंतो सेन थे उसमें
अचिंतो सेन है वो आज है अभी यहाँ पर
दूसरे कोर्ट में होंगे देखे नहीं
उनको जरा बुला दीजिए उनके पास होगी केस डायरी है ना रखते हैं आप लोग क्या करते हैं तुरंत तो नहीं डिस्ट्रॉय कर देते हो
नहीं रास्ता
बुलाते हैं।
सो टुमारो में
ऑर्डर देखिए पहले उनसे पूछेंगे उनके पास केस डायरी होगा
हाँ सुनो आइटम 11 BA 7096 of 2026
Offense under section 108 of BNS.
शादी कब हुआ
शादी नहीं हुई शादी फिक्स हुई थी एज पर FIR में लिखा फिक्स फॉर 22nd October 20th October मैं कुछ
ये जो ऑर्डर पेज 19 में लिखा है यहाँ पे गलत लिखा है सोनू तिवारी के साथ प्रेम संबंध था और इनकी शादी 29/10/2025 को होने वाली थी
Yes. And since there was love affairs, there was no demand of WL, but they are claiming that there was demand of WL, and that's why she committed suicide. But actually, your parents of
उनपे 5,41,000 cash was already
was
paid
paid, and they are further saying
and there was an allegation that 5 lakhs and one bullet motorcycle was still was further demanded.
But during investigation, no such statement had come, Your Worship. Since there was by submission, since there was love affairs, Your Worship, there was no.
The video call has been recovered.
No. As for my knowledge, Your Worship, no, that charge sheet had just been submitted on Monday, Your Worship.
The state is directed to serve notice upon the victim and file a counter affidavit in this case. It is on the learned counsel for the petitioner has submitted that although it is alleged that the petitioner had called the deceased on 16/4/26 between 10 to 11 p.m. and asked her to commit suicide, but no such video call or mobile has been recovered during
Some
investigation.
snaps were there.
During investigation. ठीक है? आप जो बोले हैं वही लिखाएं. बोलने लिखाने के पहले बीच में कुछ
Your Lordship, that is my
Let the
subject.
case diary along with its enclosures be called for from the concerned court,
Right.
including postmortem report. Notice to victim. Notice to informant. The counter affidavit be filed by 21st, post on 25th. ये जो बोल रहे हैं ना कुछ रिकवर नहीं हुआ है वीडियो और ये सब इस पर स्पेसिफिक आना चाहिए काउंटर affidavit.
Item 12 BA 7102 of 2026.
Yes, petitioner. Petitioner absent. Post on Monday. Monday को कितना cases already fixed है जरा बताइए. अगर ज़्यादा केस हो तो कोई और दिन करेंगे. चलिए next.
Item 13 BA 7103 of 2026.
Case has been registered. System only three of the beings, modern lordship. Prosecution case is that husband he had assaulted his wife lordship and thereafter she has died. Now during trial lordship 5 witnesses examined. There one child witness lordship who has given evidence against his father. Child witness lordship. And in confession, the accused lordship has confessed that Bakshar during quarrel he has assaulted his wife lordship.
काफी है. देखिए BA number 7103 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that there is an allegation against the petitioner who happens to be the husband of the deceased that the petitioner assaulted the deceased on her head and fled away from the house. He submits that one child witness who happens to be the son of the petitioner has deposed against the petitioner and claims to be the eyewitness of the occurrence. He submits that the child witness has also stated that there was that the petitioner that there was some altercation before the alleged offense. The learned counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and considering the direct and specific allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail and is rejected.
Item 14 BA 7109 of 2026.
As a request of the counsel for the petitioner, on account of non-availability of the arguing counsel, Mr. Gautam Kumar, post this case on Monday. Monday कितने cases है पहले से? How many cases are there? पहले से कितने खंड? Next. Yes, वो कहाँ है? वो ऑर्डर कहाँ है चला गया? एक केस में बेल अलाउ किए गए।
Item 10.
आज जहाँ तक हम लोगों को पता चला है कि उसमें आपने खुद ही केस डायरी प्रोड्यूस किया, तो केस डायरी आपके पास अवेलेबल है?
थोड़ा सा देखना पड़ेगा केस
हाँ,
नंबर
ये बता देते हैं आपको।
ये क्या हुआ?
आप देख लीजिए, जस्ट 2-4 दिन पहले का बात है।
हाँ, उसमें लगता है शादी वाला है।
क्या चीज?
मैरिज वाला है क्या?
नहीं नहीं, मैरिज वाला नहीं है। ये कोल माफिया थे मिस्टर
अच्छा अच्छा, हाँ मर्डर हुआ था, यस लॉर्डशिप।
आपके पास केस डायरी है?
यस लॉर्डशिप।
तो कहाँ पर है?
घर
पे? कल ले आएंगे?
Yes,
कल ले आएंगे, ठीक है?
कोल माफिया है, लेडीज का मर्डर हुआ था,
हाँ,
यस लॉर्डशिप।
हाँ, उसमें 2 का रिजेक्ट किए हैं, इनको अलाउ किए
इनको allow
बिकॉज
किए।
ही वाज जस्ट ही वाज द पर्सन हु वाज सेइंग कि मारो, अदरवाइज तो उसका कोई ओवरटैक नहीं था, इसीलिए कल आप केस डायरी सुबह 10:30 बजे ले आएंगे।
मंडे को 10 केस है।
हाँ ठीक है, मंडे को ये जितना भी एडजर्न हो रहा है सब मंडे को इसमें कम
Office
Tomorrow.
is directed
नहीं
liquid.
नहीं इसमें लिखिए post this case tomorrow बस that should be sufficient.
Item 15, BA 7112 of 2026.
साइबर मैटर इसमें कोई दूसरा काउंटर फाइल करने के लिए होगा
Post this case on 11/8/26 with BA number 2582 of 2026. किसी में केस डायरी कॉल फॉर हुआ है
जी 6582
उसमें केस डायरी तो नहीं कॉल फॉर हुआ
इसमें है इसमें काउंटर फाइल करने के लिए ऑर्डर किया
काउंटर फाइल करने के लिए ऑर्डर हुआ है
एंटीसीडेंट रिपोर्ट एनडीसी मैनेजर
इसमें केस डायरी का कॉल फॉर करने का कोई ऑर्डर
काउंटर स्टेट को काउंटर डायरेक्शन स्टेट आएंगे तो
केस डायरी का कहीं ऑर्डर नहीं
इसमें का
The learned counsel for the state is directed to produce the up-to-date case diary and indicate as to whether the charge sheet has been submitted or not. और जो antecedent report है इस तरह का You see, it is still under investigation. So you have to produce up-to-date case diary, charge sheet has been filed or not, and the antecedent.
सेम केस फाइल सीरियल 17
Serial 17 भी same,
11 पर है.
11th पर है, सब tied up, सब tagged. Serial number 17. There is one more case. I know.
17
Item 16,
आप counters में भी कर देंगे.
17 विंटर
Antecedent वगैरह सब. चलिए next.
item 16, BA 71713 of 2026.
मालूम रिपोर्ट टू दिस टाइम
Why?
मालूम इसमें 4 सप्लीमेंट्री
क्या supplement? टांगी से सर में मारे FIR में अब कौन सा था आपको supplement?
तो एलिगेशन है इंजरी वैसा
Injury नहीं है सर में.
वो वैसा इंजरी नहीं
वैसा मतलब है तो इंजरी रिपोर्ट इसमें.
इंजरी रिपोर्ट
स्कैल्प में फ्रैक्चर है काफी नहीं है क्या?
हाँ नहीं तो इंजरी रिपोर्ट जो आया है ना मैडम
हाँ.
मैडम उसमें ऐसा नहीं है काउंटर फाइल करने का बाय डायरी में
The learned counsel for the petitioner has submitted that although there is an allegation against the petitioner that he had assaulted detained Raut with tangi on his head, but the injury report of detained Raut is not supporting this allegation. Although in the impugned order it has been recorded that the scalp, hematoma and midline fracture was found of frontal bone on the head of the informant. अच्छा कोई बात नहीं, आपका जो बोले हैं सो हम लिखे हैं, ठीक है? Counsel for the state is directed to file a counter affidavit in this case. Let the charge sheet हो गया है ना?
वही इंस्ट्रक्शन लेके दो
And produce the up-to-date case diary before this court. And inform this court as to whether charge sheet has been submitted or not. यही बोले हैं इसका इंजुरी रिपोर्ट पे ध्यान देंगे है ना. Post this case on. आप तो महान है, इन्वेस्टिगेशन चल रहा है और केस डायरी आपके पास है. आप ही के कहने से इन्वेस्टिगेशन चल रहा है क्या? मतलब हमको समझ ही नहीं आता. एक्यूज के पास पूरा केस डायरी है. आयु आपके साथ मिला हुआ है क्या? फिर कैसे? Post on 14th. Counter affidavit should be filed by 13th. Next.
Item 18, BA 7116 of 2026.
Your Lordship, petitioner is the husband, the wife who was died due to accidental fire while cooking at home. And there was a matrimonial dispute back in 2024. And it has come in the order also that there was submission that in the CDR location on the date of the unfortunate incident, he was in Kolkata. And the father of the petitioner, they were both as a laborer, work as a laborers, and they were
सासू माँ ने आग लगाकर बाहर से छिटकली बंद कर दी।
This is the allegation against
डिमांड
the
आप भी करते थे कि नहीं करते थे?
yeah, that's it.
मुद्दा तो यही है। Were you also demanding wherever you were, it is in were you also involved in the demand of dowry or not?
There was some disputes back in 2024, but there was no such
When was the marriage?
2021. 4 years. And the petitioners and their family have also invested around 2 lakh rupees in her treatment. The children who are very young, they are with the grandfather and grandmother, Sasuma and Sasu.
सासू माँ के पास तो बच्चों को रहना ही नहीं चाहिए। Why are they with her?
Because nobody's maternal grandfather and parents are not taking them. They are with in their own home. And father is in custody.
Since when are you in custody?
8/6/2026.
Charge sheet not yet submitted.
Charge sheet not.
For the learned counsel submitting on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the husband of the deceased who died due to fire. He submits that the fire was accidental and it happened during cooking. The learned counsel has further submitted that the petitioner was in Kolkata at the relevant point of time. However, the charge sheet has not yet been submitted. The case was registered on 25/4/2026. The counsel for the state has opposed a prayer for bail. After hearing the learned counsel for the parties and upon perusal of the FIR itself, there is direct allegation of demand of dowry against the petitioner as well as family members. And it is alleged that the mother-in-law, after setting the deceased on fire, closed the door from outside. Considering the direct allegation of demand of dowry against the petitioner along with others, and the deceased died in a matrimonial home within 4 years of marriage, 5 years.
5 years.
5 years of marriage. And the investigation is still going on. This court is not inclined to pass the petition on this.
Children needs parents.
Children are in wrong hands. Accused के साथ नहीं होना चाहिए. Directly जो accused है उसके साथ नहीं होना चाहिए.
Directly spending.
Appearance.
को भी बच्चा माँ का प्यार होता है.
Item 19 DA 7129 of 2026.
Petitioner is a husband. Marriage solemnized in 2009.
2009.
FIR.
The allegation is that she was not giving birth to a child and therefore this incident.
इसके allegation
Visa report आया है?
नहीं.
Yes, madam. Custody कब से?
Custody है 6/2026.
Any FSL report? Must be there when there is allegation of poisoning.
तो चार्जशीट हो गया, चार्ज फ्रेम हो गया, नो विटनेस one order from second last charge has been framed in this
The state is directed to serve notice upon the informant of the case and file a counter affidavit. If any material has been sent to FSL, the report from the FSL be produced before this court in sealed cover. Let the case diary along with its enclosure be called for consent. Contract will be filed by 21st, post on 20.
Item 20, BA 7130/2026.
Name in the FIR.
Husband का क्या criminal accident का मतलब?
हो सकता है अगर previous कोई incident होता है
ऐसा बहुत कम है।
there since 5/3/26 the section 80 subclause 2 and
शादी कब हुआ?
I don't
26/11/25 within 6 months of the marriage.
26/11/25.
Cause of death strangulation.
Strangulation, pressure on
Throttling.
very नहीं आया
throttling. ये गलत लिखा है क्या इसमें? ये infant order. Doctor has mentioned cause of injury may be due to throttling
Throttling
or
or
strangulation.
and death of the disease was caused due to asphyxia caused by pressure
Demand of
blood.
dowry है?
My
Demand of dowry है?
demand of dowry का allegation तो एक मिनट देता हूँ
80 under section 80 ही तो register हुआ है case.
80 subclause 2 का
That's right. For the learned counsels appearing on behalf of the parties, the learned counsel for the petitioner suggests that the petitioner is the husband of the deceased and he has been falsely implicated in this case. He is in custody since 5/3/2026. The learned counsel for the informant has opposed a prayer for bail and has submitted that the deceased died in a matrimonial home within 6 months of marriage, and there is an allegation of demand of dowry. And also torture, both mental and physical of the wife. After hearing the learned counsel for the parties and considering the fact that the victim died in a matrimonial home within 6 months of marriage, and there is allegation of demand of dowry. The cause of death, as mentioned in the improved order, is due to throttling or strangulation, and deceased died due to asphyxia caused by pressure of great vessels on neck. The state is not inclined to enlarge the petition on bail. Hence rejected.
Item 21, BA 7133/2026.
Pass over नहीं होगा. Post this case on Monday. कल tomorrow. Other request of the council for the petition post on.
Item 22, BA 7146/2026.
False implication in a rape case, Lordship. Victim and the petitioner, they are both the relatives. Now, Lordship, in this case, basically, initially case was filed, a complaint case later on was converted into an FIR, Lordship. First incident in year 2022, subsequently 2025, this case has been filed, Lordship, and during investigation, this has stated that both the victim and the petitioner, Lordship, they were seeking the compromising position, Lordship, by a husband, Lordship. And due to extramarital relationship out of a consent, Lordship, this case subsequently CS filed in the case. So there is almost required, Lordship, this is what is done, this is the case, Lordship.
कब से custody में?
17 में 2025 हुई
Chargeशीट हो गई?
चार्जशीट शायद हो गया सबमिट हो गया
शायद मतलब
चार्ज भी नहीं हुआ शुरू में चार्ज नहीं फ्रेम कुछ नहीं
चार्ज फ्रेम की बात
नहीं
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 चार्जशीट में
चार्जशीट हो गया, चार्ज कर दिया। They were happy with me. And the husband has seen her in a compromising position. That has come in the investigation. But this is the character stated in 160 motion.
The husband had seen.
Daddy, if my lordship permit me, I'll just read the relevant paragraph.
आप तो बहुत powerful है, सारी डायरी आप ही लिखते हैं। आप लिख रहे हैं डायरी?
Daddy, I was written lordship.
कहाँ से आया? आपके पास कहाँ से आया?
Daddy supplied to the after during the after
क्यों? तभी तो investigation चल ही रहा है। अभी पुलिस पेपर आपको मिल गया?
Police paper that have to verify the information.
यही तो बात है यहाँ का, यही तो सबसे मजेदार बात है झारखंड में।
डायरी मांग
कि डायरी जो है एक्यूज खुद ही लिखते हैं, यही समझेंगे ना हम लोग। स्टेट के पास डायरी नहीं रहता है, लेकिन पिटिशनर के पास सब रहता है। इन्वेस्टिगेशन चलते रहता है, पिटिशनर के पास पूरा डायरी रहता है। हम लोग जब प्रैक्टिस करते थे तो पिटिशनर कभी अपने डायरी की बात भी नहीं करता था, लेकिन यहाँ तो ऐसे लोग बोलते हैं कि एज इफ इट इज देयर राइट। आरटीआई में लिए हैं राइट टू इन्फॉर्मेशन में। पुलिस पेपर मिल गया आपको?
पुलिस पेपर नहीं
मिला है तो आपको डायरी कैसे मिला?
There is specific provision in the sample also. All the document has to be supplied to the
पुलिस पेपर के साथ। पुलिस पेपर के साथ कहाँ से?
जहाँ तक पुलिस पेपर की बात है वो मैं वहाँ ट्रायल तो उसमें नहीं करा सकता, नहीं कर सकता।
The learned counsel for the petitioner has submitted that the FIR was lodged when the husband of the victim apprehended the petitioner and the victim in a compromising position, and this fact has come during investigation. The state is directed to serve notice upon the informant who happens to be the victim of the case. Let the case ID along with its enclosures and also the statement of the victim recorded under section 183 BNSS be called for from the concerned court, along with the stage of the case. Counsel for the petitioner has submitted that charge sheet has already been submitted. The counter affidavit will be filed by 21st August, post on 25th.
Item 23, BA 7150/2026.
Yes.
FIR is registered under section 140, 115 and 117 of BNS, but charges have been framed under section 103, 238, rated section 3, subsection 5 of BNS. The petitioner is not named in the FIR. FIR is against unknown person. Nothing has been recovered from the petitioner's.
Who is the informant of the case?
Informant of the case is lordship. The depositions are annexed in annexure 2 and 2A. PW2 is the informant lordship. It is stated page number. Lordship, page number.
In the case of going to the case ID was called for.
Yes.
ये जरा देखिए, BA number 3717 of 26.
Lordship, now two crucial witnesses have been examined, the medical officer being PW1 and the informant being PW2. Lordship, may I read the report?
They have turned hostile?
No, Lordship, they are not turned hostile. Lordship, may I state the PW1's deposition in the cross? Lordship, ने stated that कोई व्यक्ति अगर पत्थर के ऊपर गिरता है तो उक्त जख्म हो सकता है, and he stated the cause of death as injury to the head by hard and blunt object or by a fall.
इसमें केस डायरी आया था, कलेक्टेड केस में केस डायरी आया था, उसका केस डायरी लगा दिया। In the case of by considering the bail application of the co-accused in BA number 3717 of 26. The case diary was called for by mistake. Office is directed to place the case diary along with the present case and post tomorrow.
Here is this. Item 24, BA 7153 of 2026.
Case and relation section 172 and 96 of BNS. And section 6 of POCSO. And charge has been framed under section 87 of BNS and section 6 of POCSO.
You people to Kolkata.
Madam, there is a law affair between the parties, madam, and victim went to the prisoner with her own consent and solemnized marriage with the prisoner. The victim का age आया है about 17 years. अब हम supplementary में deposition भी लगाए हुए हैं. Victim का उनके informant है उनके father. तो उसमें बोल रही है कि हम अपना own consent से गए हैं, शादी भी की है, वहाँ कोलकाता से हमको पुलिस द्वारा
Victim का statement है.
victim का statement है. ये बोलती है इसमें 17 years. इस पैराग्राफ से दोस्तों मैं होगा उसके बाद फिर उसके साथ में
Petitioner का age क्या है?
17 years के प्यार में आया है और victim बोली भी है अपना birth certificate के बारे में. स्कूल में मेरी जन्म तिथि 12/9/2009.
The learned counsel for the petitioner.
तीसरा का हम सर्टिफिकेट भी लगाए हैं स्टूडेंट हमारे.
The learned counsel for the petitioner submits that the petitioner is in custody since
4/3/2026 में. 4/3/2026
charge sheet has been submitted.
चार्ज फ्रेम.
Charge trial ही चल रहा है. अभी तो trial ही चल रहा है.
Yes, ma'am.
And trial is going on. The learned counsel for the petition submits that the victim was aged 17 years on the date of occurrence. सत्रह साल की थी ना?
Yes, ma'am.
17 years on the date of occurrence, and the petitioner is 20 years of age. He submits that victim has been examined and she has stated that she went with the petitioner on her own. And they went to Kolkata and also solemnized marriage. The informant of the case has also been examined before the learned court. The learned counsel for the state has opposed the prayer for bail. However, the posted submissions made by the counsel for the petitioner is not in dispute. And evidence, considering the fact that the victim as well as the informant had already been examined, the petitioner is directed to be enlarged on bail.
Item 25, BA 7154 of 2026.
Application under section 64, 69 of the business and 137 to section 468 of the POCSO Act. Allegation in fact that informant is the father of the victim. He alleged that her daughter has come in the marriage of her brother, and in meantime, while she was going to the market along with her Jijaji, this petitioner come and trying to take her for marriage. At that time, they have raised objection और उसको ले जाने नहीं दिया. He further alleged that कि 2024 में petitioner has taken एक साल पहले 2 साल पहले 2024 में petitioner has taken her to his house and established physical relationship. Therefore, they have sent her daughter to Delhi. 2024 में उसको ले गए थे, इसलिए उसको दिल्ली हम भेज दिए थे काम करने के लिए.
इससे दूर रहे वो, इससे दूर करने के लिए.
हाँ, उससे दूर करने के लिए. Because there is admitted love affair between them, but
Admitted love affair कहाँ से बोलता है?
मतलब उस समय दोनों के बीच में 2024 में लव अफेयर था, उस समय दोनों के बीच में दूर करने के लिए उसको उस समय भेज दिया गया था, दिल्ली भेज दिया था. मैं prayer only is this case not once victim को एक बार नोटिस कर दिया जाता है, it will be
Victim has been examined as we develop one.
Victim has already been examined. He has supported the case.
supported the case, but
आप ट्रायल एक्सपीडाइट कर सकते हैं और क्या कर सकते हैं?
एक प्रेयर था, इसमें विक्टिम था, इसमें एक बार
विक्टिम को अभी नोटिस करके क्या होगा बताइए? She has already been examined ना, उसका कोई contrary statement था, हम रिकॉर्ड करके यहाँ पे आपको बेल कैसे दें? बताइए कुछ उपाय तो नहीं है ऐसे? और जलाने का
लेकिन इसमें आया है, इसके एग्जामिनेशन में आया है कि मतलब ये है उसके पहले उसके फादर ने उसको दिल्ली भेज दिया गया था उससे दूर करने के लिए. She has stated the same. और डेट ऑफ ऑकरेंस की जिस डेट ऑफ ऑकरेंस की बात बोल रहे हैं उस दिन कुछ नहीं हुआ, बस ले जाने का कोशिश किया गया था. और 1 साल 2 साल पहले का एलिगेशन लगाया जा रहा है कि 2 साल पहले उसके साथ फिजिकल रिलेशनशिप बनाया गया था, इसलिए उसको दूर कर दिया गया था. लेकिन जो डेट ऑफ ऑकरेंस जिस दिन एफआईआर हुआ उस दिन का कोई ऑकरेंस नहीं है, केवल ले जाने
ट्रायल एक्सपीडाइट कर देता है.
इसमें
कितने विटनेसेस हैं?
केवल एक विटनेस एग्जामिन हुआ
कितने
इसमें.
विटनेस हैं?
6. और इसमें एक लॉजिक और है कि ये दोनों डिफरेंट कास्ट के हैं, इसके चलते कुछ प्रॉब्लम हो
कितने
रहा है.
विटनेस हैं?
It has come in the
Six charged witnesses.
और the learned counsel से
Medical में भी कुछ
behalf
नहीं आया.
of the parties.
नोटिस कर दिया जाता है.
नोटिस करके क्या होगा बताइए? She has already been examined.
विक्टिम है, पोक्सो एक्ट है, एक बार नोटिस हो जाने से सीखा मतलब द विक्टिम.
So मैं victim
वहाँ तो hostile हुए नहीं ladies.
वहाँ तो हॉस्टाइल है ही नहीं तो क्या ही होगा? और एज डिफरेंस भी बहुत है. आप 10 साल बड़े हैं.
Victim के आने से
10 years. 10 years बहुत होता है.
होता है ज्यादा, लेकिन ये शादी हो ही जाती है. शादी
और
फादर की इन्फॉर्मेंट के बचा हुआ एग्जामिनेशन बचा हुआ है. इन्फॉर्मेंट लोअर कोर्ट में पिटीशन फाइल किए हैं, पिटीशन फाइल को उसको हम लगाए नहीं, हम तो सर्टिफाइड कॉपी अप्लाई किए. इंटायर सर्टिफाइड कॉपी है कि कास्ट रीजन के कारण, फैमिली सोसाइटी डिस्प्यूट के कारण हम थोड़ा सा केस फाइल कर दिए थे. सर्टिफाइड कॉपी ऑब्टेन किए हैं.
और the learned counsel appealing on
सिंपल है
behalf of
कि
the
नोटिस
parties.
कर दिया जाता है.
The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, as there was love affair, and there was love affair between the petitioner and the victim. In fact, the victim was sent to Delhi to work, primarily to keep her away from the petitioner. The learned counsel has also submitted that the petitioner is in custody since
Custody 16 to 2026.
16 to 2026. The learned counsel for the state has opposed the prayer for bail and has submitted that victim has been examined before the court. She is minor and she has supported the prosecution case. The trial is going on and there are altogether 6 charge sheet witnesses. After hearing the learned counsel for the parties and considering the fact that victim has supported the prosecution case even at the stage of trial, and the trial is going on, there is direct allegation against the petitioner. This court is not inclined to enlarge the petition on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to direct the prosecution to ensure compliance.
Item 26, BA 7159 of 2026.
This is a case in school 302.
Husband गला काट दिया वाइफ का रिकवरी है आपके कंसेशन पर
पार्ट चार्ट से विटनेस है जिसमें सिर्फ 2 ही हैं।
कितने विटनेस हैं
एक
आपका ट्रायल एक्सपीडाइट कर for the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 9/10/2023 and he has been falsely implicated in this case. The trial is going on in a very slow pace. Out of 8 charge sheet witnesses, only 2 witnesses have been examined so far. The learned counsel for the state has opposed the prayer for bail and has submitted that there is a direct allegation against the petitioner that he, being the husband, had cut the neck of his wife, and it has also come in the imprisonment order that the murder weapon was recovered from a concealed place on the basis of confession statement of the petitioner. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner, this court is not inclined to enlarge the petition on bail. However, there can be no excuse for the state for not producing the witnesses promptly before the court. The state is directed to ensure that the remaining witnesses are promptly produced before the court. If there is any FSL report to be forwarded to the court, steps be taken so that the FSL report is also forwarded to the court. The counsel for the state is directed to communicate this order to the Director of Prosecution and SP of the concerned district. That's it.
Item 27, BA 7161 of 2026.
302 husband. 2 witnesses were already coming in.
Custody of say.
6/4/23 से कस्टडी में है।
There is recovery from you at your confession statement.
Yes, एक logbook stick में है।
आपका ट्रायल एक्सपीडाइट कर सकते 2 विटनेस एग्जामिन हो चुके हैं out of
Out of 9.
For the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 6/4/2023. The charge was framed under section 302 on 17/8/2024. But out of 9 witnesses, only 2 witnesses have been examined so far. The learned counsel for the state has opposed the prayer for bail and has submitted that there is direct allegation against the petitioner of assaulting and killing his wife, and murder weapon was also recovered on the confession statement of the petitioner, and therefore the petitioner may not be enlarged on bail. After hearing the learned counsel for the parties and considering the direct allegation against the petitioner, this court is not inclined to enlarge the petitioner on bail. However, there can be no excuse on the part of the state not to produce the witnesses from them. The petitioner is admittedly in custody since 6/4/2023. The state is directed to produce the remaining witnesses promptly before the court. If there is any FSL report to be produced, The same we also obtained from FSL ranking and we forwarded to the concerned court. The learned counsel for the state is addicted to communicate this order to the SP of the concerned district and also to the director of the state.
Item 28, BA 7167 of 2026.
Section 62. Section 16 is the file from the pretext of marriage was established relationship.
Custody कब से?
Custody is 12/6/2026.
चार्जशीट तो नहीं हुआ होगा।
इनपुट ऑर्डर में तो नहीं है अभी। फायर नहीं है, लॉर्डशिप की शादी नहीं हुआ इसलिए
ग्रामीणों द्वारा देखने पर हल्ला करने पर वो जब पकड़े गए तो FIR हुआ है सल्ला के और what nature?
109, 126, 115, 303
लेकिन इस तरह का एलिगेशन में तो अलग नेचर का एलिगेशन। It seems that when they were caught red-handed, then she lost their FIR. We call for the statement recorded under section 183. The state is directed to serve notice upon the informant of the case who also happens to be the victim and file a counter affidavit on merits. Let the statement of the victim recorded under section 183 BNSS be called for from the concerned court. The state shall also produce up-to-date case diary with its enclosures on the next date of voting. Counter affidavit be filed by 21st, post on 20th.
Item 29, BA 7171 of 2026.
Leadership, the FIR is registered under section 10 of the POCSO Act and the Juvenile Justice Act.
Juvenile Justice Act.
Section
Are you a
7.
juvenile?
No, the petitioner happens to be aged 45 years.
So,
The victim was.
what is the age of the victim?
Age of the
And
victim
what is the allegation against
allegation
you?
marriage. Allegation.
Read the FIR. Since when are you in custody?
Marriage I'm in custody since 6 February 2026.
Charge sheet has been submitted under
Well,
which
the
section?
charge has also been framed. One witness
Under which section?
charge has been framed.
74, 75, 96.
74, 75, 96 BNS.
इसमें 4 से credits.
Charge is 74, 75, 96 of BNS and section 10(6)(7) of POCSO Act.
And section 10(6).
The JJ Act is also there. 75, 76,
75, 76, 77.
JJ Act would perhaps not apply on this petitioner. Petitioner is aged about 45 years.
Yes. What is the allegation against?
Allegation.
One witness has been examined.
Minus the victim herself has been examined.
She is hostile.
Yes, ma'am. Your Worship, the real the process, the crux of the case is that this victim was in love affair with the son of this petitioner. They ran away from home. They stayed together. The victim and the son of the informant. Thereafter, the son of the informant, he did not solemnize marriage with the victim. He went to Delhi. This victim was left, and he ran away to Delhi.
Then how the petitioner became an accused?
Well, she has stated in the FIR that
You
petition.
just read her deposition.
Well, page 22. इस कांड के अभियुक्त सादा प्रसाद मेरा कोई नहीं, सादा प्रसाद इज द पिटिशनर, मेरा कोई नहीं लगता है, वो मेरे गांव में पड़ोसी है। मैं चांडिल स्टेशन में खाना पकाते थे तो पुलिस वाले हमको बोला कि सादा पेपर में साइन कर दो, तो मैं डर से सादा पेपर में साइन कर दी। अभियुक्त सादा प्रसाद मेरे साथ कोई गलत काम नहीं किया है और मुझे इस बात की जानकारी नहीं है कि उस पर क्यों केस हुआ है। मैं सादा प्रसाद के बेटा विकास को भी नहीं जानती और ना ही पहचानती हूँ, ना ही उनके साथ मेरी मुलाकात हुई। मैं कक्षा 2 तक पढ़ी हूँ, मेरा जन्म तिथि मेरा स्कूल का नाम प्राथमिक विद्यालय बालेपुर बेहर कला जनपद संत कबीर नगर उत्तर प्रदेश है और जन्मतिथि से घटना के संबंध में मैंने जिला बाल संरक्षण इकाई सरायकेला खरसावां की परामर्शदाता रीना रानी गुप्ती को बताई थी और मेरे बताए अनुसार उनके द्वारा लिखा गया है जिस पर मेरा हस्ताक्षर है। घटना के संबंध मैंने कोर्ट के मजिस्ट्रेट साहिबा के सामने संबंध बयान दी थी जिस पर मैंने अपना अंगूठा का निशान लिया। यही मैं she had medical refused for medical examination.
क्या करना है मैडम? He is completely hostile.
But the allegation is against him is procuring the victim and engaging her for
Begging, they are beggars, madam. This petitioner himself is a beggar, madam, a man of personal locomotor disability. I have specifically stated. And they were begging on the railway station. RPF Chandil came and they.
इनका तो मेडिकल भी नहीं हुआ.
नहीं.
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petition summons that the petitioner is in custody since 6/2026. In connection with the alleged offence. The charge has been framed under section 74, 75, 96 BNS and section 10 within bracket 6 of
10, 6, 17.
10, 6 and 17 of POCSO Act. 10 within bracket 6 and 17 of POCSO Act. And also under section 75, 76 and 77 of the Land Lists. The learning council submits that the victim has been examined before the learning court as PW1 and she has completely turned hostile. The learned counsel for the state has opposed the prayer for bail. However, the fact that the victim herself has turned hostile is not in dispute. ऐसा कभी मन करता है इनका बैंक अकाउंट डिटेल्स बनाने का? Not in this case, but this is happening. Victim compensation लेकर hostile.
But that is there, madam.
That is
this
there.
is the case when she was in love affair with the son, madam. The son refused to solemnize his marriage. Thereafter, she alleged something about the father.
Yes. Considering the fact that the victim has turned hostile, the petition is directed to the last one.
DT regulation.
Item 30 DA.07.08.2026.
This case is under section 1032 and 61 of the BNS. But the allegation against the petitioner is that the prosecution story is that the informant along with her 5 sons went to attend the marriage ceremony. And wherein the allegation is that the petitioner, his wife and 10-15 unknown persons, with their intention to kill Malord, caused injuries with Malord.
I'm named in the FIR.
Lord, I'm named in the FIR. Lord, should we kindly have the FIR at page number 14?
Where is your name?
Malord, 10th line from the Malord top. रिश्तेदार मोहम्मद इरफान में शादी में गई थी। मैं अपने 5 पुत्रों के साथ बाराती के रूप में ग्राम सचिन सच झारखंड में मोहम्मद पप्पू खान, आई एम ट्रेडिशनल नंबर 1 मोहम्मद पप्पू खान मुलर आफ्टर की लड़की मुस्कान खातून के घर पर गई। दिनांक 9/7/2025 को रात को 11 बजे गई थी कि निकाह एवं खाना पीना के बाद जब बाराती वापस आने लगे और मैं भी अपने सभी बेटे के साथ घर आने लगी तो अपने गाड़ी की तरफ आने लगी तो मोहम्मद पप्पू खान पेटिशन नंबर 1 और मोहम्मद पप्पू खान की पत्नी पेटिशन नंबर 2 अपने दोनों पुत्र एवं करीब 10-15 अज्ञात व्यक्ति सभी ग्राम पिपरा थाना महागामा जिला गोड्डा ने एक साथ हथियार से लैस होकर जान मारने की नियत से चारों तरफ से घेर लिया एवं गंदी गाली बकते हुए कहने लगे कि इतने बाराती क्यों आए हैं
इसी बात पर जब मैंने कहा कि हम लोगों को घर जाने दीजिए, इस पर सभी लोगों ने एक स्वर में कहा कि अब तुम लोगों की लाश ही घर जाएगी, दोबारा बाराती जाने लायक नहीं रहोगी। और मोहम्मद पप्पू खान ने मेरे लड़के मोहम्मद तौसीफ को बाएं हाथ के बाईं बाह में चाकू से मारा और गिरा दिया। और मोहम्मद पप्पू खान के दोनों बेटे तथा पत्नी ने बाएं पसली के नीचे चाकू से मारा और सभी लोगों ने लाल घूंसों से मारा। मोहम्मद जाकिर को भी सर पे मारकर सर फाड़ दिया और लाठी डंडे से धक्का मुक्की करने लगे और मारकर गिरा दिया। उक्त लोगों ने मेरे लड़के मोहम्मद तौसीफ, मोहम्मद जाकिर, मुझे और मेरे साथ as per the impugned order, at page number kindly at page number 19. The postmortem report says that it is meant in the postmortem report is mentioned.
Who died?
Mohammed Tausif, the informant's son.
And it is alleged that you assaulted him.
It is alleged that I, along with my wife, two
No,
sons,
but you also assaulted him.
and this is the allegation on 10-15 other persons also.
That's
No recovery of any knife or alleged the recovery of any murder weapon. The real fact of this case is, these petitioners were coming along with the informant in one car. The car met an accident. The villagers came and stabbed them. And just to settle score, because these are my relatives, just to settle score, all the allegation has been put on me. The diary may be called for only and only related witnesses are the eyewitness and no other eyewitness. No.
Actually, it's a marriage ceremony. Only relatives must be around. Merely because the relative witnesses are the eyewitness, that does not mean that their evidence is to be discarded.
Only the informant, in the
informant herself is the victim.
In the impugned order, it has come that only on her statement, this case has been found to be true. If the diary may be called for, other statements may also be taken on, and the recovery of murder weapon has to be corroborated with the medical postmortem.
What about the case of the co-accused persons?
No co-accused has moved before this honorable court till date.
So far,
I am only praying that the diary may be called for, and kindly see, because charge sheet has been submitted, case has been committed. It was not my marriage ceremony, my lord. I was merely a guest. How will I have no locus? I am not concerned. A steady, my lord. I am since in March 9th, 2026. Petition is a labor.
the learned counsel for the state is directed to serve notice upon the informant of the case and also file counter affidavit on merits. Let the case diary along with its enclosures, including the injury report and the postmortem report, be called for from the concerned court. The counter affidavit will be filed by 21st, post on 21st.
Item 31 DA 7396 of 2026.
This is the petition of this for grant of anticipatory bail. A regular bail for offences under section 420, 467, 468, 471, 120B, 109 of 90C. In relation to provisions of 12, 13, 13(1)(a) of the PC Act, which also remotely also does not apply to me. Actually, the facts of the case is, Lordship will recollect, Lordship has seen the FIR of other cases also. So there was a PIL file here, Lordship, before this honorable court, regarding Lordship that certain encroachment over the lands which were acquired by.
Call for a counter.
The case data is already available with me.
Counsel for the opposite party is directed to file counter affidavit. The materials collected during investigation.
We have already filed the counter filed by them before the court below and also the grounds of arrest.
They have filed their counter affidavit
before the learned court below. That we have brought on record.
So, उनका counter कैसे देखेंगे? They have right to file counter.
Yes,
You have a right
no,
to file a
only
bail application raising all the plea. They also have a right.
Yes, sir. No, I was only insist for one small purpose, which case studies with my learned friend, if possible, next week.
Let them file a counter affidavit. It's not case diary only takes it. How much time do you need? Next to next week should be sufficient. Post this case on 20th of August. The counter affidavit should be filed by 19th.
Under reading for admission, item 32, ABA 3281 of 2026.
इसके दिनों का बिल हमारा हुआ है और टेक्निकल मार्केट.
I just pray for possible and this case for having seen it. These are legs. Just possible for two cases.
Madam, today we are not taking up Passover matters. We can adjourn it for the next week since he's on leaves.
If it comes with the
Counter affidavit filed.
Yes, yes,
please.
affidavit.
Yes.
Your case and decision for Mrs. Cognizance has been taken under section C 120B that is 424. Now they are said to be the directors of the chief fund leadership. This and that is evident from the authorship also because the directors
Directors of chief fund company.
Yes, the chief fund company name is Mrs. Vasundhara Green Power Limited.
Mrs.
Vasundhara Green Power Limited.
Vasundhara
Green Power Limited.
Green Power Limited.
This petitioner along with Abhijit Chatterjee and the Ranjan Barai, they were the directors of the company. Although it has been alleged that total collected amount is 9 crore 55 lakhs 86,500.
The amount of rupees 616 is still unpaid.
Yes, 6 lakhs, 6 crore 60 lakhs.
338 has been paid.
330 has been paid, Your Lordship. This is Abhijit Bail, Your Lordship, as per standard and annexure 4, Your Lordship.
Page number?
Annexure 4, page 153, Your Lordship.
Page 153.
153 of my page. Charge sheet has been submitted. Charge sheet has been submitted in this case. Page 153. Abhijit Chatterjee also one of the directors. That is paragraph 3 mainly. Learned counsel for the petitioner has submitted that petitioner is one of the directors of the children fund company. There is allegation of not paying the unpaid amount to the investors to the extent of itna. He has further submitted that out of this has been refunded. The last page, the relevant portion is at page 155.
So you want same order?
Yes.
Did you cooperate during investigation?
Charge sheet is already submitted.
Someone is
Same order
issued,
in
someone is issued,
now.
but the petitioners are evading the appearance that we have.
Evading because I have applied for anticipatory bail since the bail has not been granted. So I'll cooperate with the trial. It's not that I have taken my recourse. I have applied for the anticipatory bail. My anticipatory bail was rejected, then I have come here.
Same order can be passed. For the learned counsels appearing on behalf of the parties, the learned counsel for the petition submits that the petitioner happens to be one of the directors of chief fund company, namely Mrs. Vasundhara Green Power Limited. It is alleged that a total amount of rupees 9,55,86,100 was collected through local agents, and just further come that an amount of rupees 3,38,88,165 has already been refunded to the investors and the remaining is unpaid. The learned counsel submits that in connection with another co-accused who was also the director of the company, order has been passed on 10th of April 2026 in AD number 967 of 2026 in connection with Abhijit Chatterjee. The learned counsel submits that the petitioner has cooperated during investigation. And similar order may be passed as in AB number 967 of 2026. The learned counsel for the CBI has submitted that summons have been issued to the petitioner by the concerned court, but the petitioner has not yet entered appearance. However, he has no serious objection if similar order is passed as in AB number 967 of 2026. After hearing the learned counsel for the parties and considering the aforesaid submissions, we draw the similar order, same order.
Yes, same order.
ये connection 4 में है page 153. This is a paragraph copy करते हैं. In terms of that. उसमें देखिए annexure 4 में allowed है कि disposal
Item 33, ABA 3355 of 2026.
Yes. Annexure 4 is disposed of. Whatever
Annexure
they have to give the progress also.
Yes, yes. After hearing this application, we consider as per the person who was disposed of.
Disposed of.
With the observation that the one's petitions are in the.
Yes.
Lordship, the counsel has undergone a surgery. Lordship, he is admitted in Paris.
When you want.
On Monday, the coming month. He would be discharged today or tomorrow. So,
We have for PC Acts matters, we have only Thursdays.
next
You have filed your counter.
Yes, in fact, one of the filed it long back, and on the last occasion, our time was taken. So, it's health concern also.
ABA number 3355 of 2026. At the request of the counsel for the petitioner and on account of personal difficulty of the arguing counsel, post this case on next Thursday. In one case, I have asked you to file a counter affidavit. Have you been informed? In one case, I have asked you to file a counter affidavit. You were not appearing. I just let you know which is that case. Serial number 3.
My bad, I'm obliged. I should be.
I think somebody should have informed you by now. Order upload ho jayega.
I was some days.
No, but I am just informing you.
I'll do that.
Item 34, ABA 4158 of 2026.
You want time?
Yesterday.
You want time?
So, this is the present
A
case of
supplementary affidavit. Let me see if it is on record. It is not on record. Counter is not on record. It has been submitted that counter affidavit has been filed yesterday. Office is directed to post this case on next Thursday along with the counter.
Next Thursday, that is permitted to do online.
Oh, yes, no problem.
Today, when the matter is pending, I was called by the SCB on 6th.
We are not gone.
Yes, today it has, I have been called by the SCB by notice under section 35. They will arrest me. And then my case will be become infectious. And for that purpose only
The
the
counter affidavit is not here.
In the counter affidavit, we have mentioned that we have given him notice on 5 occasions that he has not come.
We have
also given Manoj that we went to his house several occasions. His house is locked and his whereabouts are not.
So we have stated that even without the notice we have appeared before the authority when they called me on phone. When only the Vinay Singh was arrested and he was put on under seal, after that the employees, after that
From where are you saying this?
by
ये ऐसा है ना कि जो
my
चीज़
landlord has
आपके
said that
report में
I need to reply.
If you want to reply, you file a reply.
So he said so that I said.
No, you cannot make a verbal reply like this.
That is
If
already.
they have made certain allegation against
That
you,
is
you have
already-
to respond.
That is already in the record. That already we have mentioned. That is also already in the record.
I don't know.
Yes,
They
we
have
have
made
mentioned-
certain allegation against you.
That we have already mentioned in my application that we appeared before.
Good, it's your choice if you don't want to respond.
Not-
But once you say that you have received a notice today, it is not on record. We will not take cognizance of that. We are not aware.
They have mentioned in their petition, their counter they have stated, 6th I was called. They have
Today
stated
is-
in paragraph,
today is a summons.
in paragraph 23,
You have issued the notice for appearance today also.
today also.
Yet, because of the reason he has been not cooperating, he has never appeared before us. And what we have even found, in this case, there is some specific finding which we have got. When Vinay Singh was absconding, he was using his.
See, you want investigation.
Yes, my lord.
Today is the date fixed for his appearance. We'll give him some protection, let him appear. And you can file your affidavit saying whatever material has been collected against them, then the anticipatory bail can be considered on merits if you want that. It's okay.
Prima facie, we have got materials against him. And his house was completely locked. We have, yes.
It is non-cooperation is one thing. Materials collected is another.
Yes. So drawn cooperation is one, materials collected is two.
Is
We have found the digital in his mobile. We have traced out that he was accessing from his wife's mobile the Gmail and the WhatsApp of Vinay Singh when he was absconding.
Why don't you examine it? Complete your examination. What's the harm about it?
We'll do that, but
You do it. I'll post it after 4 weeks. You will call him how many times you want to. Now he wants to be there for his examination. You complete it. But still, the anticipatory bail will be ultimately considered on the basis of materials collected during investigation. You record his statement also. There is no harm.
may I take instruction on this?
You take instructions. There is no problem about it. Otherwise, also custody में लेके भी तो exam ही नहीं करेंगे क्या करेंगे?
करते हैं लेकिन somebody who is not coming at all.
I appreciate that.
वो
Today is the
बताइए
date fixed.
हाँ.
And he is willing to.
But then to say that I am only willing to go when I get a
You
protection.
seek instructions.
I
You seek
just
instructions. So just. एक दो piece में बस.
Item 35, DA 5185 of 2026.
Wait, please. Sure. On the last occasion, we were directed to file the charge sheet of the present case as well as the complaint, prosecution complaint of PCI case, which we have filed by way of supplementary evidence. Now, the present case was lost way back in 2019. Prior to
When
that,
did you file it?
it
when
was
did you-
like 4th of August.
4th August. It is not on record. The Learned Counsel for the petition submits that a supplementary affidavit has been filed on 4th of August. However, the same is not on record. Office is directed to place a supplementary on record and post on next Thursday.
Item 36, BA 5250 of 2026, along with item 37.
So this is the petition is out of regular bill. There are two bill applications. For offenses under section 420, 467, 468, 471, 146, 32, 31D and 12 PCI. Actually, allegation is virtually related. This case also arises out of that PIL virtues relating to enforcement over names.
Who are you?
So I am also one of the purchaser. Initially, the seller gave a power of attorney, registered power of attorney in my name, wherein also there is a certification that this land is not acquired. And on the basis of that, Lordship, I transferred it to your Lordship, part of it to my wife and part of it to the wife of the next petitioner. To the next petitioner.
So you had purchased and further transfer.
The owner gave me a registered power of attorney after taking the money. And the
Owner gave you a registered
registered
power.
power.
That lady.
That lady.
Okay.
And also on that strength, I sold half to my wife, sold it on behalf of that lady, half to my wife, And half to the petitioner in the next case.
We are giving bail to some.
Yes, my the wives have been granted bail, Your Lordship. They are the purchasers. Your Lordship, so the sale deed and the power of attorney, both Your Lordship.
Where is the respondent?
Last occasion, Your Lordship had already observed that if they don't appear, but Madam was here today in
Where is she? Madam Priya Srish. For the state.
Ma'am, she is appearing in court number 4.
Court number?
4. During matter में आप लोग password.
पासओवर तो बनता है, आपका भी बनता है, उनका
नहीं शॉर्ट पासवर्ड में है लक्ष्य
लेकिन मुश्किल से 2-3 केस बचा हुआ है.
मुझे आपसे
Let us see if she is able to come. If that be so, we can take it up in the second half also. Because दो ही 4 केस बचा हुआ है.
जी But if she comes, it is already other.
Item 38, BA 6057 of 2026.
May I permit to withdraw in this case?
Counsel for the petition seeks permission to withdraw this bail application. This bail application is dismissed as well. State has
Signed,
no
sir.
objection.
Signed. Item 39, BA 6744 of 2026.
That case is in custody for 8 months, but observation unfound.
The counter was ready.
Your Lordship, I just received the copy of the counter. As per the counter, Your Lordship, they say the sanction has already been given on 3rd of July. But the instruction which I have in the court, Your Lordship, the last date was 30th July. The sanction order was not received. Next date is 13th August, Your Lordship. So after that, it may be kept, Your Lordship. So 8 months custody हो गया है, and he is अगर sanction आ जाए, he will get the charge from it. So 13th August के बाद date दे दिया.
Is there any observation that?
Observation था Your Lordship, that time we don't know if he sanction नहीं हुआ है, sanction नहीं आया था, तो we are after framing of the charge frame था Your Lordship, but charge could not be framed because the sanction was gone. So I have an example.
The counsel for the parties are present.
6,000.
The learned counsel for the petitioner submits that as per the counter affidavit, the required sanction for prosecution has come. She submits that the matter may be posted after some time.
After
so that
last date, next date, 13th.
and the next date is 13th of August.
Before the time.
Before the learned trial court. Charge उस दिन frame हो जाएगा.
Your Lordship, 13th के बाद अगर sanction put में आ गया होगा तो charge
हो जाएगा.
करा देंगे. But then also
and
13th
and there is like
27th August.
And she submits that the matter be posted on 27th. You had moved earlier, no?
Yes, we have moved earlier.
She has also submitted that the petitioner had moved earlier, and there was an observation that the petitioner may renew the prayer for bail after framing of charge.
Charge, yes.
Based on 27.
Yes.
Item 40, BA 6765 of 2026.
I have filed a supplementary affidavit in compliance of order of 13/7/2026. And I have stated that due to mistake, I have stated in para number 2 that earlier move one BA number 4198.
Okay, but you have not moved.
But I have not. So may kindly ignore this.
Yes.
And Lordship, may kindly call for the case diary and postmortem report because the PSA is 103, one of the PNS, and there is allegation only on suspicion that the petitioner has assaulted earlier and killed the victim's wife.
The counsel for the petition has filed and has referred to the supplementary affidavit dated 31/7/2026 and has referred to paragraph 3 thereof to submit that it was wrongly mentioned in paragraph 2 that the bail application of the petitioner was earlier rejected in PA number 4198 of 2025. He submits that the petitioner had never moved this court earlier for grant of bail. He submits that it may be recorded that the petitioner has not moved earlier for grant of regular bail. Considering the submission, it is now recorded that as per the petitioner, he has not moved this court earlier for grant of regular bail. अब counter file कर दीजिए आप. The learned counsel for the state is directed to seek instructions and file counter affidavit. Let the case diary along with its enclosures be called for from the concerned court. Along and also the present stage of the case. The move will be done by 21st, post on 20.
Passover case, item 34, ADA 4158 of 2026. 34.
Yes, ma'am. It is your case. No.
34.
36 and 37.
हाँ तो क्या हुआ अभी वो आए नहीं. Second half में order करते हैं. ठीक है? We'll be there in this.
Passover case, item 36, BA 5250 of 2026, along with its citation.
Last case and for directed me to provide the evidences against this.
Let's see the first one. Chaitan Kumar. Who's the husband of? So Chaitan Kumar.
I have sold.
Okay. You have sold to two ladies, and those two ladies have been enlarged on you.
No, one of them.
One.
One is my wife. She has not yet come, and one is wife of the second petitioner who has been
And anticipatory.
anticipated.
Yes, madam. What is there against Chaitan Kumar?
Jharkhand Kumar, he is the holder of power of attorney provided by Sonmai Devi. And he sold the land, and he is the ultimate beneficiary of the house because he has sold the land to his wife and wife of Rajesh Kumar, his friend.
That's right. Madam, just tell me one thing. Anybody who is buying the property will see what? What all due diligence is required from his end?
He is the power of attorney holder.
He is the power of attorney holder.
Yes, yes.
Right? And the seller has committed some error. The lady.
The seller is he himself.
That's right. The lady is the power of attorney holder of the lady.
Yes.
Right?
Can you see my counter? See. Para 11. Other witnesses have supported the prosecution case, namely Dev Singh Anchal Amin, para 3 of the case diary, para 17 of the case, has stated his statement that he himself with Tapeshwar Sai, land acquisition Amin, Sandeep Mali Amin, Circle Office, Bargai have done physical survey of the land in question, and after they informed by RIMS that those buildings and construction were not of RIMS, they have prepared the chart of those buildings of construction, boundary walls, from such and such. During the verification, it has come that Khata number 107, part number 69 was sold by Sonmai Devi to purchaser Lovely Devi, wife of Rajesh Shah. Para 87 of the case diary indicate that seller Sonmai Devi has sold the land in question 11.50 decimal for the consideration amount of 40 lakhs to Lovely Devi, wife of Chaitan Kumar, for their personal gain after creating forced family that it was known to them that appeal of Sonmai Devi, it was known to them that appeal of Sonmai Devi was already dismissed, but it was sold to Lovely Devi who belongs to general category, and this indicates that both seller and purchaser have conspired for the personal gain.
This lady, Sonmai Devi, belongs to ST category?
No, she is general.
She is general.
She filed an application
As
under
a
71A claiming
was
herself to be the history. She filed an application under section 71A in the year 1993 claiming herself to be ST. Court gave a finding that she has not been able to prove that she is a member of scheduled tribe. the circle officer was directed in that proceeding that you make an inquiry and give it to the rightful owner. Circle officer made an inquiry in 1993 and handed it over to Salmat Devi, and Jamabandi was opened in our name. That time my age was 12 years, I had no relation. So in 2022, when she gave a power of attorney, I got it verified. Kindly see page 64 for a moment. The authorities give a certificate that it is not an acquired land. And Rashid, this honorable court directed the SCB to inquire into those officers, and they are being made witness, and the purchasers are being made an accused. Lordship, may kindly come to page 64.
16.
Page 64, Your Lordship. This is the registered power of attorney which was given to me by Sundat Devi. On the pretext that she will not be able to go time and again to the registry office. She gave it and said that you give the money to me and you get executed. Lordship, may kindly see in the bottom, who urgent, दर्ज नहीं है, one भूमि नहीं है. In the top, Your Lordship, may kindly see, पशुपालन या भू की such and such नहीं है. गैर मजरूह प्रतिबंधित सूची में नहीं है. All the three stamps are there.
This is the registered power of attorney.
Registered power of attorney. After taking the certification from all the departments.
Madam, you tell me that anybody who is holder of power of attorney, the property was standing in the name of this Sonmai Devi. As per the records, as per registered to, right? The fact that it was acquired, no entry was made in registered, correct? And there is also a certification that it is not under the.
It is an
acquired
admitted
land.
fact that all
It
have
is an
connived.
admitted fact.
All
With
have
whom?
connived.
With whom?
Officers of the CO office and
That's right.
They are also
Officers of
connived.
the CO office has connived, and the seller is this Sonmai Devi. He is only a power of attorney.
he has taken only he already know the fact. That's
See,
why I'm
everybody has
SAR
certified.
case
How do you know he knows the fact? How do you impute knowledge to him?
You ladies should kindly see my
What is there?
para 14 of my call.
Yes, what is there to impute knowledge to the petitioner that he knew that this is an acquired land?
As per the Sonmai Devi statement.
How much did you sell?
In para
How much did you sell?
11.5 decimals to my wife and
Sonmai Devi
11.5 decimals to my friend's wife. And Lordship, to Rajesh Jha, my friend. And Lordship, may kindly see para 12. They admit that I paid 40,33,000. Lordship, if I know that it is an acquired land, why should I pay? I put a question to myself. Why should I pay 40,33,000? It is not a small amount. And this they term in the later part that this amount is a meager amount. But 1 lakh rupees also a person will not part.
Yes.
Statement of Sonmai Devi, para 110 of the case. Para 6.
Para 6.
आपके नाम से जवाबबंदी पंजीकृत है कायम हुआ उसकी जानकारी किसके माध्यम से प्राप्त हुई? इस संबंध में भू दलाल लोग सोनू शरण, प्रमोद कुमार महतो, राजेश झा, मनोज कुमार बड़ाई एवं चेतन कुमार, इन सभी लोगों के द्वारा पंजीकृत में खाता 107 प्लॉट संख्या 1693 की मेरे नाम से जमाबंदी कायम उनकी जानकारी दी गई एवं उस जमीन की खरीद बिक्री करने के लिए बातचीत की। वे सभी लोग उस जमीन का पावर ऑफ अटॉर्नी लेने और जमीन को खरीदने के संबंध में बातचीत की। इनके द्वारा बताया गया कि मुझे कुछ करने की जरूरत नहीं, केवल जमीन की खरीद बिक्री के समय रजिस्ट्री कार्यालय में आकर अंगूठा लगा देना हो।
But the fact that the property was standing in her name in registered 2 is not in dispute. Correct?
But it was known to them that not belongs.
ये कहाँ से बोल रहे हैं? It was known to them that the land was an acquired land.
Because they have approached her.
No, they might have approached her. Anybody who wants to buy the property will approach the seller. What's the big deal about it? The seller may approach the buyer may approach the seller. The land was recorded in her name. It is very much there. What all due diligence does the petitioner require to do while buying a property? आपको खरीदना होगा तब क्या देखेंगे? Register 2 देखेंगे, mutation देखेंगे, possession देखेंगे और क्या देखेंगे?
और इसके लिए ही ये पहले अपने फ्रेंड को बेचा, राजेश कुमार झा को बेचा,
अपनी वाइफ को बेच सकते हैं,
फिर अपनी वाइफ को बेचा।
There is no power. There is no power. A power of
दिखाने के
attorney
लिए
holder.
मेरे पास 2 सेल थी।
No. A power
Sir,
of attorney
subsequent
holder.
sir.
A power of attorney holder can sell property to his wife. There is no power. He can sell property to his brother. There is no part. But what is there to connect that the petitioner had prior knowledge that this is an
The
acquired
statement
land?
of Sunlight Devi?
This para 6?
Yes.
No, that is not
They have-
sufficient. That is not sufficient.
My para 14 of the my
I will
contract.
take care of it. Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner happens to be the power of attorney holder of Sonmati Devi, Sonmait Devi, in whose name the property was shown even in register 2. The learned counsel further submits that the power of attorney was a registered document which has been annexed along with the anticipatory bail application. Which has been annexed along with the bail application and which reveals that there is a certification that the property does not fall within the acquired land. यही है ना?
जी acquired land नहीं है, वन भूमि नहीं है,
And
prohibited list में
it does not fall, it further does not fall within the forest area, nor does it relate to animal husbandry scam. The learned counsel submits that on the strength of the power of attorney, he sold 11.50 decimal to his wife by a registered deed and another 11.50 decimal to the wife of his
to Rajesh
one
Kumar Jha.
Rajesh Kumar Jha. The learned counsel submits that the entire transaction is bona fide, and since the property was recorded in the name of Sonmai Devi, there was no impediment in purchasing and selling the said land.
This document which was shown to the lady here, this is not verified by any officer. It is just an power of attorney.
That's you go and verify. आपको investigation आप continue करिए. This is the registered document. It's a registry document. The learned counsel submits that the transaction entered into by the petitioner, being the power of attorney of Sonmai Devi, while executing the sale deed, are bona fide transactions, and the petitioner is in custody since
7/4/2026.
7/4/2026. Charge has been framed.
Charge sheet has been
Charge sheet has already been submitted. The learned counsel for the ACB has opposed the prayer for bail and has submitted that the petitioner had full knowledge of the fact that the property was falling under acquired land for ribs. She has referred to the statement of Sonmai Devi recorded under section 183. 183 का statement है ना? 180 of BNSS, paragraph 6, and submits that the petitioner along with other co-accused, namely Sonu Sharan, आपका क्या नाम है?
राजेश झा और चेतन
सोनू शरण, प्रमोद कुमार मेहतो, राजेश झा, Manoj Kumar Badaik, and Chetan Kumar had approached Sanmai Devi and told her that the property is standing in her name in register 2. And they all asked her to give power of attorney to them, and she would be only required to come to the registry office for execution of sale, for execution of document in connection with sale purchase of property. To this, the learned counsel for the petitioner has submitted that the sale statement does not reveal that the petitioner had any knowledge that the property is falling under acquired land for ribs. After hearing the learned counsel for the parties and considering the fact that even on the registered power of attorney, it has been certified by the concerned authorities that the land does not fall under acquisition, forest land, and is not falling under craftsman lease, or is not a part of transaction under animal husbandry scam, and also the fact that the property was running in register 2 in the name of Sonmai Devi, who had executed the power of attorney in favor of the petitioner, who ultimately sold the land to 2 persons through registered sale deed. This court is of the considered view that the statement of Sonmai Devi in paragraph 6 by itself does not reveal that the petitioners had knowledge that the property was the acquired land of kings. The fact remains that charge sheet has already been submitted. In such circumstances, the petitioner is directed to be released on bail. ये चेतन कुमार, और ये राजेश झा
had purchased 11.5 decimals with
same ही लिखिएगा. So far as Rajesh Jha is concerned, he is the purchaser of 11.50 decimals of land from the petition from
Sonmai Devi through her power of attorney.
From Sonmai Devi through her power of attorney, namely Chetan Kumar, who has been enlarged on bail by this court by in BA number 5250 of 2026. और बाकी सब सेम ही. ये सब बाकी ऑर्डर हो जाए.
This is the case diary for the first matter which the election has listed out. Because नहीं आएगा तो फिर president लौट जाने से.
एक कौन सा?
मुझे serial 31 में.
सीरियल 31 में
डेट फिक्स कर दी.
डेट फिक्स कर दी. हाँ, काउंटर के लिए बोलिए.
हाँ, खाली मैं डायरी अगर रिटेन कर लेने तो अगर उस दिन
इसी का ही है.
इसी केस का बिल्डर है वो. उसका डेवलपमेंट एग्रीमेंट में दिया था and he took a No incumbent certificate
You
of
can
30
retain
years.
the case diary, madam. You have got the case diary? वो 30 serial number?
31 years.
30 उसमें counter के लिए भी order किया है.
Counter के लिए.
It has been posted on
28.
28.
28, नहीं,
20th.
27.
20th.
20. So you retain the counter affidavit. This case diary for that. Yes, what do you say?
But he may appear and will not arrest. The lady should be put in no cause.
लिखिए उनका file. Heard the learned counsel pleading on behalf of the parties. The learned counsel for the opposite party has submitted that he has filed a counter affidavit in this case. Which is not on record. However, he has submitted that in the counter affidavit it has been mentioned that one notice has been issued that the petitioner has not cooperated with investigation and had not appeared on various dates, but one notice has been issued to the petitioner under section 35 for his appearance today also. To this, he has also submitted that the house of the petitioner was locked on various occasions. To this, the counsel for the petition has submitted that if appropriate order is passed giving certain protection to the petitioner is ready to appear before the ACB in their office pursuant to the notice given today. Considering the submissions, since notice has been issued for the petitioner for his appearance in the ACB office and the date is fixed today also, this court is of the view that the statement of the petitioner be recorded by the ACB and accordingly the petitioner is directed to appear in the ACB office today. कोई time है? कहाँ है?
Karachi में. After 1 hour, 2 hours, anything.
By 3 o'clock? हम order upload कर देंगे. By 3 o'clock, and would also continue to appear on various dates as may be directed by the concerned officer of ACB. Pose this case on 10 September.
Either 3rd or 17th.
On 17th of September, if the petitioner cooperates with the investigation, till 17th of September, no coercive steps be taken against the petitioner, subject to the condition that he would cooperate and appear before the authority. In case the petitioner does not cooperate,
Does not appear basically. They will say कि आया कुछ बोल नहीं रहा है.
does not appear on the dates fixed, it will be open to the opposite party to take all coercive steps.
The dates will be given in writing to me.
He will be present, will tell him the dates.
In writing दे दो तो अच्छा. Otherwise बोले कि कल बुलाया पाए नहीं.
इतना मिसट्रस्ट मत है.
जो writing एक दे दे जो otherwise कोई भी आपको दे दे कि कल आना है. बस
ऐसा हम लोग किसी के साथ नहीं किया है. इतना मिसट्रस्ट मत.
ठीक है.
के दूल्हे हुए तो आप भी नहीं.
हम भी नहीं.
कितना नहीं सोचने का है. हम लोग चाहते हैं कि भाई आप कोऑपरेट करिए, जो हो ट्रायल हो, जो हो कंप्लीट हो. नहीं तो यहाँ तो इतना दिन तक कुछ होता ही नहीं. This is what we want, nothing more. बेस्ट है जब उनका रिकॉर्ड करें उसी में नेक्स्ट डेट इनको साथ ही
साथ वही करते हैं. नेक्स्ट डेट बता देते हैं.
नेक्स्ट डेट वही पर
In fact, I can only say out of the court in ACB, मतलब जो होता है जनरली इंट्रोगेशन में हम लोग एक झापड़ भी आज तक किसी को नहीं मारेंगे. मतलब this is I am saying it with all responsibility.
ठीक.
किसी को एक there is not even a single
We are
word which
posting it on 17th. You will file a supplementary affidavit by 17th.
Before that 16th.
Supplementary affidavit in connection with the conduct of the petitioner and also the materials collected during the interrogation of the petitioner we placed on record by 16. यहाँ से बोल के करेंगे ना तो रिकॉर्ड क्या है?
हाँ, वो इनफैक्ट कल भी पोल की परमिशन नहीं हुआ था। नहीं ऑर्डर अच्छा ओके कल yesterday since it was recorded in the order तो वो शायद नहीं आया। We'll take permission from here.
इनको खाली बता देने से आ जाता